5 seconds to go. Start. This appeal arises from an order dated 2nd March 2022 of a single judge of the High Court of Delhi in bail application number 196 of 2022. The second respondent is facing trial in connection with FIR number 894 of 2014 dated 18th November 2014 for alleged offences punishable under sections 363, 364A, 302 and 201, read with section 34 of the Indian Penal Code 1860, registered at Police Station Gandhinagar, District, East Delhi. Following the submission of the charge sheet under section 173 of the Code of Criminal Procedure 1973, charges have been framed. 11 prosecution witnesses have been examined. The appellants are the parents of the deceased, who was a 13-year-old class 8th student. The case of the prosecution is that he was kidnapped for a ransom of rupees 1 crore and his dead body was recovered from a nala day after the kidnapping of the child. The second respondent was arrested on 25th November 2014 and was in custody except for the period when he was released on interim bail until 2nd March 2022. Dr. Menka Guruswamy, senior counsel appearing on behalf of the appellants, submits that the High Court has proceeded on a manifestly erroneous premise that PW3 Urvashi, who deposed during the course of the trial, is an approval. Crucial witnesses including PW15, the caretaker, and PW16, the landlady, remain to be examined. The material which has emerged during the course of the investigation and the trial would militate against the grant of bail, and the High Court has proceeded on the erroneous premise that besides the testimony of PW3, no other witness has been cited as against the second respondent. Mr. Siddharth Dave, senior counsel appearing on behalf of the second respondent, on the other hand, urged that the second respondent was in custody for over a period of 6 years. Considering the fact that only 11 out of 55 witnesses have been examined at the trial, the order granting bail does not warrant interference. The second respondent had furnished his voice sample, unlike the co-accused who had refused to do so, and the report of the forensic science laboratory has not been produced on the record. PW3, who has turned hostile, is a witness in the nature of an accomplice, since, according to the prosecution, she was present at the premises where the child was brought. The call data records do not specifically pinpoint the location of the second respondent, and on the above grounds and having regard to the period of custody undergone, there is no valid reason for this court to interfere with the order granting bail. The submissions which have been urged on behalf of the appellants have been supported both in the counter affidavit which has been filed by the NCT of Delhi as well as during the course of the submissions by Mr. Jayant K. Sood, Additional Solicitor General for the NCT of Delhi. Stop.